We have breaking news. The U.S. Supreme Court has blocked the Trump administration from deploying the National Guard in Illinois. In a 6-3 decision, the Supreme Court ruled they will not allow the White House to deploy National Guard troops to the Chicago area as a legal challenge moves forward. CBS News immigration and politics reporter Camila Montoya Galvez joins us now. Camila, what did the justices say in this decision? And is this sort of a stay or is this on the merits?
Well, to justify his attempts to deploy the National Guard to Chicago, Portland, and Los Angeles and other cities across the country, the President Lindsay has argued that violent protesters are obstructing and interfering with federal immigration operations, including by ICE and Border Patrol, and that the National Guard is needed in these Democratic-led cities to protect immigration agents and also facilities where detainees are held. In this case, specifically focused on the Chicago area attempted deployment, the majority of the High Court has said that the Trump administration actually did not meet the requirements in the federal law it cited to justify the deployment of the Guard there in Illinois. The majority of the court said, and I quote,
"Good to have you. Welcome back to John Podcast." The Supreme Court, with 3 Trump-appointed justices, struck down his attempt to call up National Guard units in Illinois, ruling he had not identified a source of authority for the action. The blunt language was a constitutional sledgehammer. When the government's lawyers cannot find any legal basis for a presidential claim, the claimed power simply does not exist. The ruling in Trump versus Illinois involved a specific request that reveals the scale of what the administration was attempting. Trump wanted to deploy about 300 Illinois National Guard members for immigration enforcement in Chicago. 300 troops is a substantial force, and they would have been used for arrests, detentions, and other law enforcement activities in a major American city. But the court blocked it. They upheld a lower court order that barred the deployment, and they did so by pointing to something called the Posse Comitatus Act, a law that has stood as a bulwark against domestic military deployment for nearly a century and a half.
Before the president can federalize the Guard under the relevant statute, he likely must have statutory or constitutional authority to execute the laws with the regular military and must be unable with those forces to perform that function. At this preliminary stage, the government has failed to identify a source of authority that would allow the military to execute the laws in Illinois. We should add that the conservative justices, 3 of them dissented, and this does not change the status quo because the deployment of the National Guard to the Chicago area had been blocked previously by lower courts.
You also have some new reporting about how the administration is tossing out some asylum cases. What can you tell us?
So the Trump administration is planning to deport up to 1 million people per year who are in the country illegally. But it is facing one major challenge and hurdle, and that is that many of the people it is seeking to deport have active asylum cases, including the hundreds of thousands of people who cross the border unlawfully under the tenure of former President Joe Biden. To circumvent that and bypass that process, ICE attorneys across the country under the direction of the administration are asking immigration judges to effectively dismiss the asylum cases of people.
The Posse Comitatus Act, passed in the aftermath of the Civil War and Reconstruction, establishes a general ban on using the military for civilian law enforcement. The act prohibits the Army, and later the Air Force and other military services, from being used to enforce civilian laws within the United States. The prohibition is the default. There are exceptions, but they require specific statutory authorization. And when the Supreme Court asked Trump's lawyers to identify any exception that would authorize the deployment they were seeking, they could not do it. The has not demonstrated a source of authority finding is devastating in its simplicity. The government had the burden to show a legal basis for the action. They failed to meet that burden, and the failure means the power Trump was claiming simply does not exist. The vote was 6-3. That is a substantial majority, and it includes conservative justices who Trump and his supporters might have expected to support him. The ruling against Trump by a court that is considered Trump-tilted sends a powerful message. The message is that even friendly courts will not rubber stamp everything. There are limits.
Welcome back. We are following breaking news out of the Supreme Court, which has just blocked the Trump administration from deploying the National Guard in Illinois. The justices rejecting the White House's claim that the troops were needed to protect federal agents carrying out immigration enforcement, particularly in and around the Chicago area. The decision represents a rare defeat for this administration by this conservative-leaning court. Joining me now is NBC News senior Supreme Court reporter Lawrence Hurley. So, Lawrence, what did the justices say in their ruling?
Yeah, I mean, as you said, this is a pretty significant setback for the Trump administration, because the court was saying here that this law that the Trump administration was trying to use to deploy National Guard in Chicago basically couldn't be used at this point, because that law says the president can deploy the National Guard when the regular forces are unable to execute the laws. And the court said regular forces doesn't refer to local police, it refers to the US military. And even if you could try to bring in the US military to do this, there weren't any circumstances that would allow that to happen either. So
constitutional and statutory that apply even to presidents who appoint justices. And when those limits are exceeded, the court will say so in the most direct language available. The emergency request that Trump made was an attempt to get a quick ruling without full briefing and argument. Emergency requests ask the court to act immediately, and they are typically granted only when the requester can show irreparable harm from delay. The denial of the emergency request means the court did not see such harm. It means Trump cannot deploy while litigation continues. And the denial is especially significant because the court was not willing to allow the deployment even at a preliminary stage where deference to the government is usually greater. If the court won't allow it now, it is very unlikely they would allow it after full briefing. Let's look at the specific case that brought this to a head. The district judge who first blocked the deployment was April Perry, a federal judge in Illinois. She issued an injunction prohibiting the deployment, and the Supreme Court left that injunction in place. Her analysis found that there was no credible evidence that there is a rebellion or danger of rebellion in Illinois. That finding is crucial.
Double restriction on the president's ability to use this law as he's been trying to use it so far. And there were 5 justices who signed on to that out of the 9. So that, is a significant setback for this administration.
And there was a split, though, among the court's 6 conservative justices. What do you make of that?
Yeah, I mean, you see this, the conservative majority on the court isn't always in lockstep. There's 6 conservatives, 3 of them were in dissent this time. And they said at this point, this kind of preliminary point in the case, they thought that the president had the better of these arguments. But even then they were kind of divided on to what extent they thought, the president could do this. I think Justice Neil Gorsuch, for example, seemed pretty lukewarm about the whole thing, but just said it's preliminary, so we shouldn't be weighing in. So there's lots of moving parts in this case. They actually took a really long time to decide it, even though it's supposedly on the emergency docket. And that's a sign of how the court, found this a difficult one to deal with.
And of course, this is just the situation in Illinois. Will this ruling apply to sending National Guard troops to other parts of the country, or is it just Democratic-led states?
Because rebellion is what would be required to justify military deployment under the Insurrection Act, a separate law that Trump might try to invoke in the future. Judge Perry also found that civilian law enforcement was functioning in Illinois. The normal authorities were handling the situation. There was no need for military intervention, and the no need finding undermines the entire justification for the deployment. Illinois officials argued that the deployment was political punishment rather than legitimate security. They said Trump was targeting a democratic state that has resisted his policies, using the military as a weapon against political opponents rather than as a tool for actual law enforcement. And Democratic governors from California and Oregon joined in warning about the consequences. They said that unchecked guard deployments would let Trump occupy hostile cities. That is, strong language, occupation, suggesting military domination of American cities that oppose the president politically. The warning was that if Trump could send troops into Illinois against the state's wishes, he could do the same in California, Oregon, and anywhere else that resisted his agenda. The Supreme Court's ruling now strengthens similar challenges in other states. The consequence is that when Trump tries to deploy troops in California or Oregon or any other state that has resisted his policies, the legal precedent from this ruling will make it much harder for him to succeed. The ruling is the first time the court has drawn a clear line against Trump's expanding use of emergency military authority at home. It is unprecedented in the Trump era. A clear line means unambiguous limit. The drawing of the line is what makes this a nuke move. The nuke is the most powerful weapon. The move is the court's action. And the collapsing is what happens to Trump's claimed authority. When the court says the power he was claiming does not exist. The constitutional and statutory dimensions of this ruling need to be understood clearly because they go to the heart of fundamental questions about presidential power. The Constitution grants Congress the power to raise and support armies and to make rules for the government and regulation of the land and naval forces. The Constitution also provides that the president is commander-in-chief of those forces. But the commander-in-chief authority is not unlimited, and it does not include the power to use the military domestically for civilian law enforcement without congressional authorization. That is what the Posse Comitatus Act establishes, and that is what the Supreme Court just affirmed. The Posse Comitatus Act was passed during Reconstruction, when federal troops were being used to enforce civil rights laws and maintain order in the former Confederacy. The act was intended to limit the use of military forces for civilian purposes to prevent the military from becoming a domestic police force that could be used against American citizens. The act has been amended over the years, but its core prohibition remains. And the exceptions that have been created, such as for drug enforcement or counterterrorism, are specific and limited. They do not provide the broad authority that Trump was claiming. When the Supreme Court said that Trump had not identified a source of authority that would permit the military to enforce the laws in Illinois, they were not just saying that the specific deployment was problematic. They were saying that the entire legal theory underlying the deployment was invalid. The administration had been arguing that the president's commander-in-chief authority, combined with various statutory authorities, gave him broad discretion to deploy troops domestically whenever he thought it was necessary. The court rejected that argument. They said that the president's authority is limited by statute and by the Constitution, and that the limits apply even when the president claims emergency circumstances. The statutory limits that the court pointed to are laws passed by Congress that restrict domestic military deployment. The Posse Comitatus Act is the primary restriction, but there are others. The courts pointing to these limits means that the restrictions are real and enforceable. They are not just political preferences that can be ignored when the president thinks they are inconvenient. The restrictions apply to the president. They are binding on the executive branch, and when the executive branch violates them, the courts can and will step in. The failure to show rebellion undercuts Trump's potential argument under the Insurrection Act. That act, passed in 1807 and amended several times, authorizes the president to deploy troops domestically in cases of insurrection, rebellion, or domestic violence. But the act requires specific factual findings. The president has to be able to show that there is actually an insurrection or rebellion happening. Judge Perry found no credible evidence of that in Illinois. The civilian law enforcement was functioning. The normal authorities were handling the situation. There was no emergency that required military intervention, and the Supreme Court left that finding in place. The political punishment rather than legitimate security argument from Illinois officials is significant because it goes to motive. The officials argued that Trump was not actually concerned about security in Chicago. They said he was trying to punish a state that has resisted his policies. The deployment was about politics, not about law enforcement. It was about showing strength and intimidating opponents. And the Supreme Court's ruling effectively validated that concern by saying that the legal basis for the deployment did not exist. If the deployment was not justified by law, then its true motive becomes highly suspect. The Democratic governors from California and Oregon who joined in warning about the consequences were not just making political noise. They were raising a constitutional concern of the highest order. If the president can deploy military forces against states that oppose him politically, then the federal system of government breaks down. The states are supposed to have a degree of autonomy and protection from federal overreach. The military is not supposed to be a tool of political domination. The governors were warning that unchecked guard deployments would let Trump occupy hostile cities, and the Supreme Court's ruling is a direct response to that concern. The ruling strengthens similar challenges in other states. That is a practical consequence of enormous importance. If Trump tries to deploy troops in California or Oregon or any other state that has opposed his policies, the governors of those states can now point to this ruling. They can say that the Supreme Court has held that the president has not demonstrated a source of authority for such deployments. They can say that the legal basis for the deployment does not exist. and they can use the ruling to block the deployment through the courts. This is the first time the court has drawn a clear line against Trump's expanding use of emergency military authority at home. That characterization from experts describes the significance of the ruling. The first time means unprecedented. The clear line is unambiguous. The Trump's expanding use describes what he has been doing, claiming more and more authority as he pushes the boundaries of presidential power. The emergency military authority is the specific power being limited. The at-home qualifier distinguishes from foreign deployment, where the president has much broader authority. At home, the limits are real and enforceable. The new congressional debates over war powers and domestic deployment that the decision is likely to force describes the political consequences of the ruling. Congress has been accused of ceding power to Trump, of allowing him to expand executive authority without pushback. This decision gives senators and representatives new cover to write laws limiting domestic deployments. They can now point to the Supreme Court ruling and say that the courts have spoken and that Congress needs to act to clarify and strengthen the limits on presidential authority. The emergency declarations and spending freeze tactics that Trump has used to bypass Congress are related areas where legislation could be passed. The bigger fight over executive power that the ruling connects to is the broader question of presidential authority in the Trump era. The bigger fight includes many cases and controversies. The executive power is the power of the president. The fight is between those who want to expand it and those who want to limit it. The ruling is one battle in that fight. The broader Supreme Court docket on presidential authority includes other cases where Trump has pushed limits. The tariffs cases challenge Trump's use of emergency authority to impose sweeping tariffs on foreign countries. The control of independent agencies cases involve Trump's claims to direct agencies that are supposed to be independent of presidential control. The FTC firing case will test whether Trump can fire commissioners of independent agencies without cause. Each of these cases involves executive power. The possible outcomes could supercharge or further constrain the unitary executive theory. The unitary executive theory holds that the president controls all of the executive branch and that Congress cannot create independent agencies or limit the president's removal power. The supercharge would be expanding that theory. The further constraint would be limiting it. The Trump versus Illinois ruling constrains presidential authority on domestic troop deployment. The future rulings will determine the overall direction of executive power in the Trump era. The Congress has been accused of ceding power to Trump. That characterization describes the legislative branch's role in the expansion of presidential authority. The ceding power means giving up authority. The accused suggests that this is a criticism. The Congress has failed to check Trump in many areas. The failure has enabled his expansion of executive power. But this decision gives senators new cover to write laws limiting domestic deployments. The new cover means political protection for action. The senators now can point to the Supreme Court ruling and say that the courts have spoken and that Congress needs to act to reclaim its constitutional authority. The Trump-tilted Supreme Court saying no characterization of what happened is significant. The Trump-tilted reflects that Trump appointed 3 of the current justices. The saying no is ruling against him. The ruling against by his own appointees undercuts his claims that courts are biased against him. The saying no shows even friendly court has limits. The cracking his strongman image consequence goes to political perception. The strongman image is Trump presenting himself as powerful leader who gets what he wants. The cracking is damaging that image. The Supreme Court saying he cannot deploy troops cracks the image. The cracking affects how supporters and opponents perceive him. The signaling to lower courts and blue state governors' consequence describes the broader effect of the ruling. The signaling is sending message through the ruling. The lower courts receive guidance on how to rule on similar cases. The blue state governors receive encouragement to resist future deployment attempts. The successfully resist future deployments is what the signal enables. That makes it much harder for Trump to use the Guard as domestic weapon assessment from commentators describes the practical effect. The much harder means significantly more difficult. The use of the Guard is deploying National Guard troops. The domestic weapon is using troops against American cities. The harder means he faces greater legal obstacles. The riot control and immigration weapon purposes describe how Trump wanted to use the Guard. The riot control is suppressing protests. The immigration weapon is enforcing immigration laws through military. Both uses would have been civilian law enforcement. Both are restricted by Posse Comitatus. The in blue states qualifier identifies where Trump wanted to deploy. The blue states are states that vote Democratic. The Democratic states have resisted Trump's policies. The resistance made them targets for punitive deployment. The ruling protects them from such deployment. The forcing him either to back down or try even more extreme moves describes Trump's options. The back down means accepting the limit. The more extreme moves means escalating beyond what the court blocked. The either-or framing shows the constrained choices. The invoking the Insurrection Act is the more extreme move Trump might try. The Insurrection Act authorizes military deployment in cases of insurrection or rebellion. The invoking would require Trump to claim rebellion exists. Judge Perry found no credible evidence of rebellion. The invoking without evidence would face legal challenge, and the challenge would likely succeed based on the ruling. The 2026 politics forcing a choice describes political consequences. The forcing a choice means Republicans must decide. The choice is whether to back Trump's push for domestic military power or side with court and state leaders. The defending local control alternative is what court and state leaders represent. The high-stakes split is what viewers expect from this story. The historical significance of this ruling will be studied. The first clear limit on Trump's domestic military authority, the limit imposed by court he shaped. The record documents what happened when President pushed too far. The fundamental question is whether limits exist that even Trump cannot exceed. The ruling says yes, the limits are constitutional and statutory. The exceeding them produces rejection even by friendly court. The nuke move characterization captures the significance. The nuke is the most powerful weapon. The move is the court's action. The collapsing is what happens to Trump's claimed authority. The collapsing is complete. The authority does not exist. The domestic troop deployment power that Trump claimed was unlimited. The unlimited claim is rejected. The limited reality is what the court established. The establishing of limits is the nuke move. The not identified a source of authority finding is the core of the rejection. The not identifying means complete failure. The source of authority that does not exist cannot be exercised. That cannot be exercised is the limit. The permit the military to enforce laws in Illinois is what Trump wanted. The permit was denied. The denial is comprehensive. The comprehensive denial collapses the claimed power. The "I can send troops anywhere" claim that Trump has made is repudiated. The anywhere is not unlimited. The limits are enforced by courts. The enforcement constrains presidential power. The bottom line is this: the U.S. Supreme Court just pulled a nuke move collapsing Trump's executive powers on domestic troop deployments. They ruled 6-3 that his administration has not demonstrated a source of authority that would permit military enforcement of laws in Illinois. The court denied Trump's emergency request to deploy about 300 Illinois National Guard members for immigration enforcement in Chicago. They upheld a lower court order that barred the deployment. They pointed to the Posse Comitatus Act's general ban on using military for civilian law enforcement. Judge April Perry had found no credible evidence of rebellion and that civilian law enforcement was functioning. That undercut Trump's emergency justification. Illinois officials argued the deployment was political punishment. Democratic governors from California and Oregon warned that unchecked guard deployments would let Trump occupy hostile cities. Commentators say this is the first time the court has drawn a clear line against Trump's expanding use of emergency military authority at home. The ruling will make it much harder for him to use the Guard as a domestic riot control and immigration weapon in blue states. The ruling forces Trump either to back down or try even more extreme moves like invoking the Insurrection Act, which would face challenge based on the finding of no credible evidence of rebellion. This is one of the clearest examples of a Trump-tilted Supreme Court saying no to his most aggressive use of executive power. It cracks his strongman image. It signals to lower courts and blue state governors that they can successfully resist future deployments. The ruling strengthens similar challenges in other states. It forces new congressional debates over war powers and domestic deployment. For 2026 politics, Republicans must decide whether to back Trump's push for domestic military power or side with a conservative court and state leaders defending local control. He has not demonstrated a source of authority, finding collapses Trump's claimed power to send troops anywhere. The not identifying any legal basis means the authority simply does not exist. The Nuke move is the Supreme Court establishing a clear limit that even a president who appointed 3 justices cannot exceed. The domestic deployment fight will continue as Trump decides whether to back down or escalate to the Insurrection Act. The stakes could not be higher for the constitutional order.